Hey, Happy New Year, everyone. Good morning. My name is Jason Ishii, Chairperson of the Authority. I would like to now call to order the January 4th, 2023 Kakaako Authority meeting of the Hawaii Community Development Authority. The time is now 9:01.
Thank you, Chair. In accordance with Section 92-3.7 Hawaii Revised Statutes, the Hawaii Community Development Authority is holding today's Kakaako board meeting virtually on Zoom. The Zoom link details were included on the meeting agenda. Therefore, members of the public are welcome to join us on Zoom and also at our physical meeting site at the American Brewery Building, 547 Queen Street, second floor boardroom, Honolulu, Hawaii, 96813. The meeting is being live streamed on HCDA's YouTube page. The HCDA communication staff is hosting this meeting. Once this meeting begins, everyone will be muted for clearer audio. Board members, if you have any comments or questions, please unmute yourselves to speak. This is a public virtual meeting, so to prevent any distractions, if you are not a board member, staff member, or HCDA's Attorney General, please turn off your video during the meeting. If you are providing public testimony, your name will be called accordingly. Please turn your video on, clearly state your name and affiliation and proceed with your testimony. When you are finished, please turn off your video. In accordance with Section 92-3.7C Hawaii Revised Statutes, if the authority's ICT connection or the remote meeting is lost, the meeting will be recessed until the connection is restored. If the connection cannot be restored within 30 minutes, the meeting will be terminated and the authority will continue the meeting at another notice date. Thank you. Chair.
HCDA board members, please remain visible and audio during the meeting. Also, please acknowledge you are present by either saying here or present. Let the record reflect the following members are present. Vice Chair Apo.
Here.
Member Higa.
Here.
Member Miranda Johnson.
Here.
Member Salaveria. Member Hirai.
Here.
Member Wicker.
Present.
Member Wicker present. Member Sakota.
Here.
And Member Hasha. We have quorum.
7 members.
Okay, we have
We
quorum.
have quorum, yes.
For today's meeting, board members will have an opportunity to ask questions or provide comments after an agenda item has been presented. Individuals from the public who have requested to provide verbal public testimony on a specific agenda item are on standby and will be permitted into the meeting respectively. First item, the regular meeting minutes of December 7th, 2022. Board members, are there any comments or corrections to this minutes? If there are no comments or questions,
All right.
the minutes. Okay.
Member Higa, 2 corrections. So on page 3, it's just a typo in paragraph 6. Member Higa asked for a timeline rather than the current at. And I know it's a minor thing, but on page 5, the second to last paragraph, it should be LIHTC, LIHTC, rather than LITCH as it is currently. Other than that, though, I have no other amendments.
Thank you, Member
Thank you,
Higa.
Member Higa. Yep.
Any other comments or questions or changes to the minutes?
Approved as corrected.
If there are no comments or questions, the minutes are approved as corrected. Next item on the agenda, item number 2, tab 2. Consider adopting hearing officer Wayne Nasser's recommended findings of fact, conclusions of law, and decision and order in the following consolidated contested case hearing matter, docket number ACC-2017-01 in regards to petition of the Golden Eagle Marine Charter Services Corp. This agenda item involves a matter that was on the board's August 4th, 2021 agenda. At the August 4th, 2021 board meeting, the sitting board members voted to accept the hearing officer's recommended findings of fact, conclusions of law, and decision and order in the following consolidated contested case hearing matter. In regards to the petition of the Golden Eagle Marine Charter Services Corp. Docket number ACC-2017-01. The petitioner filed an appeal on the board's August 4th, 2021 decision and order to the State Circuit Court. On appeal, HCDA's decision and order was vacated by the Circuit Court and remanded to HCDA for further proceedings due to an error in the materials circulated to the board for August 4th, 2021. We will now proceed with presentation of the hearing officer's recommended findings of fact, conclusions of law, and decision and order. Board members, a copy of the hearing officer's recommended hearings of fact, conclusion of law, and decision and order has been provided to each of you for your review and consideration. B, presentation of the record. Board members, a copy of the record in this matter has been provided to each of you for your review and consideration. And C, polling of board members to affirm that board members participating in decision-making have personally reviewed and considered the record and hearing officers' recommended findings of fact, conclusions of law, and decision order. Pursuant to the Circuit Court's remand order, board members, please verbally affirm that each of you have personally reviewed and considered a copy of the entire record, which includes but is not limited to the contested case hearing transcripts, exhibits, and written submissions by the parties and the hearing officers' recommended findings of fact, conclusions of law, and decision and order. As I call your name, if you've reviewed it, please say yes. Vice Chair Apple,
Yes.
Member Higa,
Yes.
Member Miranda Johnson,
Chair, I have not had an opportunity to review it, so I'll be abstaining from voting on this measure.
thank you. Is Member Salavera here? Excused. Member Hirai,
Yes.
Member Wicker,
Chair, I have not reviewed, so I'll abstain from this vote.
Member Sakota,
Yes.
Member Hasha, and then Chair Ishii, myself, yes.
5 members there, 5 members.
5 members, okay.
1, 2, 3. Chair, Vice Chair, Member Higa, Craig Hirai, Member Hirai, and Member Sakota.
So that's 5. You
Yeah.
have quorum.
And then Member Miranda Johnson will abstain, as will
Member Wicker.
Wicker. Okay.
Okay. The petitioner's presentation of arguments on exceptions to the hearings officer's recommended findings of fact, conclusions of law, and decision and order is counsel for the petitioner, Christopher Muzi, present.
Yes.
Mr. Muzi, would you please note your appearance for the record?
Yes.
Please approach. So thank you, Mr. Muzi.
Good morning, Chair Shi and board members. Christopher Muzzy on behalf of the petitioner, Golden Eagle Marine Charter Services Corp.
So thank you for attending. You have 10 minutes to make, Mr. Muzi, to make your arguments, and you may now proceed.
Thank you. If you don't mind, I'll just start my own timer here.
Sure.
Okay. Again, thank you for hearing from us. I represent a small business owner, and this proceeding involves the wrongful termination of the commercial mooring permit at Kewalo Basin Harbor back in May of 2017. We're here before the board for the third time on the exact same issue, the adoption of the hearings officers, November 14th, 2018, proposed findings of fact, conclusions, law, and decision regarding that permit termination. So this fight has effectively been going on 5.5 years. It's longer than the Civil War went on. And about 3 of those years resulted from delays because the board had not followed proper procedure. We went up on appeal twice and it got sent back down twice. And we're here for the third time. And I appreciate Chair Ishii going through what is required of the board members, because it is important that everyone has reviewed the record and also personally. The record here is in excess of 2,800 pages. So if you haven't seen about that much, then you should check with the Attorney General, because you may not know what's in the entire record, but that's what it was the last time we went up to appeal. So there is a significant investment of your time into this proceeding, and it matters. It matters a lot to the parties. Mr. Ho and myself have spent quite a bit of time on these proceedings, and it's important to all the parties here. And this proceeding isn't essentially to be a rubber stamp of what the hearings officer had done. Your AG can tell you the Hawaii Supreme Court has said that this board has the ability to reach a decision independent of what the recommendations of the hearings officer, and it doesn't require you to merely be a rubber stamp. For the AG's information, that site is White versus Board of Education, 54 Hawaii 10. So effectively, you guys are sitting here today as a judge. You don't have to accept what the hearings officer has found. And I'm going to explain to you very simply why what the hearings officer found requires you not to adopt his decision. And again, it's important, and I know a number of the board members may not be attorneys or may not have sat in a capacity essentially as a judge, but that's what you're asked to do here today, is to judge what's being presented to you. And we filed written objections, and those contain the detailed legal analysis and citations. But I would just really want to hit on a couple points on the merits, because I think they're really determinative. So when this appeal was filed back in 2017, the real issue was the harbor had sent a letter indicating that Golden Eagle's permit essentially either expired or was not going to be renewed. So the issue for the hearings officer really was the termination of that permit or non-renewal not proper? And the hearings officer made 2 important findings, and you guys have those findings with you. And those are actually under conclusions of law number 12 and 13. And those are on page 9 of 17. And they're real short. And I want to just start with conclusion of law 12. The hearings officer concluded that Kewalo Harbor did not comply with HAR, Hawaii Administrative Rules, section 15-212-48, by failing to give 30 days to cure the default. And then the first sentence of the very next finding says, due to the violation of the cure period, and that's the harbor's violation of the cure period, the purported termination of the permit prior to its expiration was ineffective. So really what the hearings officer should have been dealing was a binary decision. Was the termination proper or not? And he found that it was not proper because the harbor had violated Hawaii administrative rules by failing to allow for a cure. So at that point in time, the hearings officer should have essentially said, okay, there was a violation by the harbor. They violated the administrative rules. The administrative rules have meaning. That's what governs the operation of the harbor. The permit should have been reinstated for the balance of the period of time that the hearings officer determined it was valid. That was a 9-month period. But unfortunately, the hearings officer went further. The hearings officer said, well, when the permit would have come up for renewal in 9 months, Golden Eagle would have been in default. Well, that's completely speculation. You cannot base a decision on speculation, a conclusion of law on speculation. The hearings officer didn't know what would have happened 9 months in the future. The hearings officer doesn't know whether or not the alleged defaults would have been cured by that period of time. The hearings officer doesn't know what would have been presented to the harbor. The hearings officer does not know what would have happened. Nobody knows what would have happened because the harbor essentially sent the notice terminating the permit and demanding that the vessel be removed from the harbor. So really, the hearings officer's rationale for trying to justify effectively the termination of that permit is that, yeah, in the future, they probably would have been in default, so no harm, no foul. But that's, again, entirely based on speculation. Because the permit had been terminated, because the harbor said, get out of the harbor, we will never know what happened. So really, this board should stop when the hearings officer determined that there was a violation of the Hawaii administrative rules by the harbor. And because of that violation, their attempt to terminate the permit essentially was wrongful. So really what the harbor is asking, or what the hearings officer has found, is not reasonable. It's not reasonable for this board to affirm a decision that essentially is based on speculation. What may have happened at a certain period of time that would have justified the result. The board can look at the decision, look at what the hearings officer found, and really all that was at issue was that May 2017 termination proper or not? And the hearings officer found that the Hawaii administrative rules were violated. And at that point, what this board should do is find within its power that's granted or that the Supreme Court recognized, the board can find that the permit was improperly terminated and essentially allow for Golden Eagle to have the balance, the 9 months that was left on its permit, reinstated. That's fair, that's reasonable, and it follows from the decision that was made by the hearings officer once you take out the speculation and assumption. Unless the board has any further questions, that would be the conclusion of my presentation. I think I have a couple minutes left that I would just reserve for rebuttal if necessary.
Thank you, Mr. Muzi. Is there any questions on the board? No, thank you.
Thank you.
Respondents' presentation of responsive arguments to the petitioner's arguments on exceptions. Is counsel for the respondent Brian Ho present?
Yes,
Mr. Ho, would you please note your appearance for the record?
thank you. Chair Ishii, members of the board, my name is Brian Ho. I am the attorney for the respondents, which is Kewalo Harbor LLC and Kewalo Harbor Management Company LLC. I'm going to be very brief. The trial in this case was conducted over 2 days of hearing where witnesses came and testified live. Written evidence in the form of exhibits and pleadings were submitted to the hearing officer, and he submitted his proposed findings in November of 2018. If you read those proposed findings, you'll see that they're very detailed, they're very thorough, they track all of the evidence accurately. Contrary to what Mr. Muzzy has said to you this morning, where that decision and the conclusions of law were based on speculation, that's not true. That's not supported by the evidence, because the decision by the harbor people that the permit was expired and not subject to renewal occurred in February 2017. The petitioner, Golden Eagle, filed their request for a contested case in April 2017. This case didn't go to hearing until August 2018. So during the period where Mr. Muzzy is saying the hearing officer looked into the future and made a decision based on speculation is not correct, because that time actually passed. Golden Eagle was allowed to remain in the harbor and continue operations by agreement of the lawyers until this case was finally decided. So we know exactly what happened in that time period after February 2017 through today. And that evidence, as far as what happened between February 2017 and August 2018, when the case went to hearing, was part of the evidence introduced at trial. So there's no basis for anyone to find that hearing officer's decision was based on speculation. I just want to note in closing that, you know, if anybody has any questions, I'm ready to answer it, but I think the record and the decision is clear. It's, you know, it's well supported and very thorough.
Thank you, Mr. Ho. Board members, do you have any questions for Mr. or comments for Mr. Ho?
Thank you very much.
Mr. Muzzy, do you have any comments responsive to Mr. Ho's presentation?
Yes, just real briefly. I think there's a disagreement between council as far as what would have happened during that time period while the hearings officer issued his ruling after the 1 year or the remainder of the permit would have expired. Really, if the board looks at the letter that effectively terminated or said that that the permit would not be renewed, there was not the opportunity for Golden Eagle to try and cure defaults and apply for a new permit. Golden Eagle was told to vacate the harbor, and there was never any suggestion that they would be allowed to stay if they tried to cure the defaults. So what we're dealing with was Golden Eagle not having that opportunity to even try and cure. So the hearings officer in November of 2018 had to look back and assume what would have happened during that time period. And he made assumptions that they would have been in default at the time of renewal. And because of that, the harbor would have been able to choose not to renew the permit. That again is all speculation because Golden Eagle never had that opportunity to try and cure the default and renew its permit. Thank you.
Thank you. Any questions? Mr. Muzzy? No. No, thank you very much.
Thank you.
Is there any public testimony on this matter?
No.
No. The meeting agenda notes that the board may convene in executive session pursuant to HRS section 92-5A4 to consult with board's attorneys or on questions pertaining to the board's power, duties, privileges, immunities, and liabilities for the subject agenda item. Is there a motion to enter into executive session pursuant to HRS section 92-5A4? Vice Chair Apo? Oh, you're on mute, Vice Chair Apo.
I so move.
Is there a second?
Member Higa seconds.
The motion to convene to an executive session has been made by Vice Chair Apo and seconded by Member Higa. Members, is there any discussions on this motion? All those in favor say aye.
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 Any opposed, say nay. We will reconvene this meeting immediately following the executive session. I will ask that in addition to board members, that Craig Nakamoto, Executive Director, Deputy Attorney General Kelly Suzuka, HCDA staff Tomlin Soares and Francine Murray, please join us in the executive session. The executive session is expected to last approximately 30 minutes, and the time is now 9:26. All attendees will be placed in Zoom virtual meeting room or will be asked to wait into another room if they're present at the physical location. Please announce all the names, Vice Chair.
Oh,
So does it mean?
yeah, you can do it.
Okay.
Wait till we get into the, wait till we get into the. Let me to take this part. Let me to take this.
Okay.
Okay.
Irene, are you there?
And Kapili, can you get the parties from downstairs? Yeah. Thank you.
Can I comment?
Oh, hold on, first, hold on a second, member of poll. We're live.
Okay.
We're live right now.
I just want to be sure that Irene can hear you guys when you start. Irene, can you hear us?
Yes, I can hear you. Hold on. I was just trying to get back up. Okay.
We're waiting for the attorneys to return to the room.
9:50.
Okay. I'm ready whenever you are.
Yeah, yeah.
We'll just reconvene the public meeting and we'll take that.
Yeah.
From there. Yeah.
Okay, ready.
All right, the public meeting is now reconvened and the time is now 9:53.
Thank you, Chair. Mr. Muzi, Mr. Hope, can you come up?
Sure.
So, Mr. Muzi, Mr. Hope, the board again, thanks you for your presentation, the time you spent today. It was very informative. The board has, considered, your presentation, but has, decided to defer this matter, taking action on this matter, and suggest to the parties that they meet in mediation to try to settle this matter, and that we calendar this, a hearing again for a month, in hopes that in a month you can mediate and settle this matter.
I don't see how we're gonna be able to schedule a mediation
Okay, well.
and I don't have authority for that. I don't know about you, Chris, but they're logistical.
Sure. Do you need maybe 2 months to schedule and arrange a mediation? I mean, I know mediators are tough to schedule, but can you do it in 2 months?
I don't even know if I would get authority to do that.
Okay, well, I think, that's our suggestion.
Right, sure.
So I think, why don't we?
We can calendar it and come back.
Yeah, why don't we say that we're gonna defer taking action on this? And then we're gonna suggest to the parties that they meet in mediation to try to settle this. And then at the point where the parties have either settled it or are unable to even get into mediation, then let us know and then we'll calendar a rehearing. How's that?
Can I ask one question?
Sure.
Would it be possible to calendar it for a month? And then in that time period, I imagine we will both know if the clients will authorize it, and we will investigate how long it would take to schedule it if there's an agreement by the parties to do it. And then we could let Kelly Suzuka know that that's the road we're going down, and the board can then push it back further with the additional information. If the parties don't get authority to mediate, then we're on schedule and there's not any further extended delays. That would be my request and suggestion.
And Mr. Woozy and Mr. Ho, the board meets on the first Wednesday of every month, so.
Sure.
You know,
Yeah, I was just gonna bring up the scheduling issue. I'll be actually out of country for the February board meeting. So to the extent that there would be any input required of me, I won't be available for the February meeting.
schedule it for March, Mr. Ho.
I was just thinking if we're gonna come back in February, it's just gonna be for decision making. Can Lila come and attend? I mean, there's not gonna be any further argument.
I mean, I guess the decision making would, I mean, theoretically, you guys could just issue their decision.
That's-
right, without. Yeah, I mean, as long as there's no input that's going to be required,
February.
in February, then, that would be fine.
Okay. All right.
Yeah.
We guys, okay, all right, so February subject, if, we need more time, then you can continue move the hearing back,
Right.
with back, or if you say you haven't been able to reach any, agreement and mediation, then we'll just calendar it for February.
And that would be decision making, no further
Decision
argument
making,
by the
decision-
lawyers.
Decision making, yeah.
Yeah, I think that's the efficient way to go if you all don't mind.
Is that okay?
We can just see where we are in February.
Yeah, okay, sounds good, so,
So we'll know
okay,
before
so,
February.
thank you.
Thank you. Appreciate it.
So Chair, if I can maybe verbalize the motion.
Okay.
So the motion is going to be, is there a motion for the authority to defer action on hearings officer Wayne Nasser's recommended findings of fact, conclusion of law, and decision and order in the following consolidated case hearing matter in petition of the Golden Eagle Marine Charter Services Corporation, docket number ACC -2017-01. And two, recommend that the parties meet in mediation to try to settle this matter. And calendar hearing, another hearing in 1 month, the February meeting, subject to continuing that or rescheduling to March if the parties are moving towards some kind of settlement. Something like that. Look good?
So moved.
So
Moved by Mr. Wright. Do I have a second?
Second,
Second.
Who was that? Sorry.
Dane Wicker.
Second by Member Wicker.
okay, it's been I'm gonna take the roll.
Yes.
On the motion made by Member Hirai and seconded by Member Wicker. Member Hirai. Aye. Member Wicker.
Aye.
Member Ishii.
Aye.
Member Apo.
Aye.
Member Higa.
Aye.
Member Miranda Johnson abstain. Member Sakota
Yes.
and Member Hasha excused.
Member Wicker.
Member Wicker voted, I think. Yeah, yes. So 1, 2, 3, 4, 6 yeses. 1 abstain. And no votes. 7, yeah.
Seven.
Seven, sorry. Okay. 7 yes votes, 1 excuse, 1 abstain.
Thank you.
Thank you.
Thank you.
Thank you very much.
Okay, next item on the agenda. Requests to establish a permitted interaction group pursuant to Hawaii Revised Statutes 92-2.5B to determine the requirements and qualifications for designating a non-governmental entity as a buyback agent for HCDA reserved housing units that are intended to be sold during the reserved housing units regulated term and present the permitted action group's findings and recommendations to the authority. Ms. Lindsay Doy, Asset Manager, will now present HCDA staff report. Lindsay.
Thank you. Good morning, members. This report is located in tab 3 of your packet. It's essentially step 2 following the petition for waiver of administrative rules that was heard last month in December. So this is, again, the second step in HCDA's, I guess, quest to designate additional buyback agents for our reserve housing units that will come up for sale during the regulated term. So it's not, we're not trying to figure out the criteria yet. We're simply trying to establish a permitted interaction group with members of the board to help us determine the guidelines for securing and procuring that buyback agent, the non-governmental buyback agent. So that is kind of the limited scope of this action. It's just to designate the permitted interaction group. After we get that group together, that's when we would be talking about the requirements, the various items that would go into that procurement to selecting a buyback agent.
Okay. Members, are there any questions or comments on the staff report?
Question,
Member Hurai?
just, is there a problem with HHFDP?
We actually really enjoy our relationship with HHFDC. We're just trying to broaden the scope. I know that HHFDC has been unable to buy back units in the past few years, so we have had to waive buyback on those units. We would prefer not to waive buyback. We would prefer for them to be kept affordable. Correct. So they would still be kept on. Our agreement still stands with HHFDC as a governmental agency, but now we want to expand to non-governmental as well.
Any other questions for Lindsay or comments? Is there any public testimony? Is there? So members, so there's no question. So we need to, is there a motion for the authority to establish a permitted interaction group pursuant to Hawaii Revised Statutes 92-2.5B to determine the requirements and qualifications for designating a non-governmental entity as a buyback agent for HCDA reserve housing units that are intended to be sold during the reserve housing units regulated term and present the permitted action group's findings and recommendations to the authority.
Member
have a
Higa,
motion?
so motions.
Member Higa, is there a second?
Second.
Second by Vice Chair Poll. Members, is there any further questions on the motion or discussions? If not, Lindsay, can you take the roll call?
Okay. Members, the motion has been made and seconded. On that motion, Member Higa,
Aye.
Member Apo,
Aye.
Member Miranda Johnson,
Aye.
Member Harai,
Aye.
Member Wicker,
Aye.
Member Sakota,
Yes.
and Chair Ishii.
Aye.
The motion passes with 7 in favor and 2 excused.
Thank you, members.
Thank you.
And now maybe we can ask for volunteers.
Yeah, so, yeah. So is there any volunteers to be part of this PIG group? Permitted action group?
You have to have less than 5.
You want me?
If you'd like to, you have unique expertise.
Yeah, you'd be good.
Okay.
Thank you, member Hirai.
Member Hirai is volunteered.
Anyone else would like to volunteer?
Member Higa volunteers.
Thank you, member
Thank you.
Higa. Anyone else?
It's good. You have good expertise.
Yeah, I'll,
In the two of them.
I'll volunteer.
Okay,
I want to be a
excellent.
part of it.
Excellent.
Okay,
Okay, thank you.
thank you. So we have members, Cherry Shi, member Higa, and member Hirai volunteering for the pig.
Great.
Thank you, member.
Thank you.
Thank you, everyone.
Okay, next item on the agenda, tab 4, monthly report and other status report. Approved permit applications that did not require HRS 206E-5.6 public hearings. So Craig Nakamoto will now present the monthly report.
Thank you, Chair. In the interest of time, members, the report of the executive director is attached and for your information. And if you have any questions, I'm happy to answer.
Any questions or comments on the board? To Director Nakamoto's report? No? Okay. Thank you. Is there any public testimony? No? All right. Well, thank you for those who joined us on Zoom, in person, or via YouTube. This concludes our business for today. The meeting is now adjourned and the time is 10:07. Yeah, we're going to take a 5-minute break and then we'll go into the